this morning is the case entitled State of Vermont versus Charles Stroble, case number 24 AP 348. Representing the appellant Charles Stroble is Nader Hashim. Representing the appellee, the state of Vermont, is David Gartenstein.
All right, thank you very much. Counsel for the appellant, please introduce yourself and your client, and then you may proceed with your argument.
Good morning, and may it please the court. My name is Nader Hashim, and I'm the attorney for the appellant Charles Stroble. In this case, the court should reverse the trial court's decision to continue holding Mr. Stroble without bail pursuant to 13 VSA 7553. There are two grounds for reversal. First, the trial court's decision was arbitrary, and second, it was a clearly unreasonable exercise of discretion in light of the evidence presented. In this case, the defense is requesting this court to focus on the trial court's conclusion that Mr. Stroble failed to meet his burden to overcome the presumption of pretrial detention.
Sorry, you were not the attorney during the initial hold without weight of the evidence case, correct?
That is correct, Your Honor.
And at that time, the appellant's attorney agreed that the evidence of guilt was great against your client. Does that make a difference in how the court analyzes the proceedings from here on?
I believe that it may impact whether or not the court considers how substantial and serious the allegations are.
Doesn't it also impact the presumption?
Yes, Your Honor.
May I ask a question now that you're paused? In any of these hearings, has the court ever agreed that any person would be suitable for condition, a supervisory condition, a responsible adult condition? Has that ever been agreed to by the court, subject to identification of a person?
For Mr. Stroble, I'm not aware of any potential adults who could supervise him if they were presented to the court.
Okay, well, that's not quite my question. My question was, has the court ever said they would agree to a supervised adult condition? In other words, that anyone would be suitable? Or has the court not ever weighed in on that issue of whether they would impose that condition if there were a suitable adult?
Understood. No, Your Honor, I have not seen the court make that statement.
Thank you. There's been a number of hearings here, and I just wanted to be clear that I had the background right on that. You may proceed. I'm sorry to interrupt you.
Thank you.
So I just want to follow up on something Justice Eaton said. That there's been two options for a responsible adult: his mother and his, I guess, girlfriend. It's kind of unclear what the relationship is, but those are the two options that have been presented to the court.
Those were the first two initial options that were presented at the weight of the evidence hearing. And then most recently, the fiance's sister was presented as an alternative.
And did the court, do you think the court adequately considered those in making its determination as to an appropriate person?
I believe that they adequately considered the first two individuals, the fiance and the mother. I don't believe that they adequately considered the fiance's sister.
And so as to the burden shift, once the evidence of guilt is great, then it becomes discretionary with the trial court as to how and if there would be conditions of release that would be appropriate, correct?
Yes, Your Honor.
And I know before I interrupted you on your first question, that's where I believe you were going with your argument as to how that was an abuse of discretion to not exercise the right to some type of supervised detention.
Yes, Your Honor. May I proceed?
Oh, yes, I'm sure. I'm sorry. Go ahead,
Just-
please do.
Check, thank you. We know that in the 7553 analysis that if the state is able to meet its burden regarding the weight of the evidence for a life offense charge, that the presumption is pretrial detention and the burden shifts to the defendant. The purpose of this appeal is not to relitigate whether the weight of the evidence is great. That issue has been conceded. Rather, the purpose of this appeal is to address the trial court's ruling, given that the defense presented a material change in circumstances. These changes specifically address the trial court's original concerns that it raised in its entry order from the weight of the evidence hearing in June. When Mr. Stroble had his weight of the evidence hearing, the trial court expressed two primary concerns about the first proposed responsible adult, Barbara Rollo, and the location of her residence. First, there was the concern that the proposed responsible adult did not take the charges seriously and would not provide reliable supervision. Second, there was concern about releasing Mr. Stroble to Windham County, the same county in which at least one of the alleged victims still resides. Additionally, during the June hearing, after the weight of the evidence was conceded, the state itself provided that in the second phase of a 7553 hearing, the trial court shall consider both the risk of flight and risk of harm to the public when deciding whether or not to exercise its discretion for pretrial release. It's also been a consistent view of this court that the touchstones for evaluating the trial court's exercise of discretion are the risk of flight and risk of danger to the public. The defense raised a substantial number of points, such as the fact that the allegations are over a decade old. Mr. Stroble returned to Vermont to be arrested. He has no criminal record, and there's no evidence of threats to any other children or anyone else in the years following the allegations. During the bail review hearing in November, the defense presented two alternatives to the proposed responsible adult location, requested the court to impose strict conditions of release, and specifically raised the issue that the newly proposed alternatives were meant to address the trial court's original expressed concerns. The defense presented Ms. Pauline Watson, who clearly understood the responsibility involved in supervising Mr. Stroble. Additionally, Ms. Watson was identified as a good choice from the defense perspective because her residence is in Windsor County rather than Windham County. It is the defense's position that the trial court abused its discretion because it erroneously interpreted the statutory requirements for who may serve as a responsible adult, while also using a clearly unreasonable rationale for denying approval of Ms. Watson as a responsible adult. Additionally, the trial court used faulty logic in rationalizing concerns about proximity. Specifically, the trial court held that Ms. Watson did not have a significant ongoing relationship with Mr. Stroble, even though there was both a family and work connection. Even so, regardless of the nature of their relationship, a significant ongoing relationship is not a statutory requirement. The statute requires that an individual or organization consents to provide supervision. Additionally, Mr. Stroble has no criminal background. He has substantial ties to the community. He was previously employed full-time, and the alleged conduct is said to have occurred years ago. The issue of proximity rests on an arbitrary and faulty logic. The court initially raised concern about Mr. Stroble being released to Windham County due to proximity to at least one alleged victim. The proposed residence with Ms. Watson was in another county, and the court raised that Mr. Stroble could not be released to a county that was adjacent to Windham County either. And I would also like to...
Your client's 52 years old, no criminal history whatsoever, a few motor vehicle incidents, but no criminal convictions that I could see. And then he's been gainfully employed. What I couldn't figure out was how long he'd been gainfully employed. Do you have that information?
I apologize, I don't have that information in front of me.
No problem.
I would also like to address the credibility of Ms. Watson. In the appellee's brief, the state describes her as dishonest. The state is encouraging this court to make findings in the first instance about Ms. Watson's credibility. The trial court is generally best suited to make findings about whether a person is credible or not during their testimony. The trial court made no such findings, nor did the state timely and specifically raise that Ms. Watson was dishonest during the hearing. That issue was not preserved for review, and it is inaccurate to describe her as dishonest. Additionally, the state cites State versus Blaisdell as a justification for prohibiting approval of Ms. Watson as a responsible adult because the time frame in which defendant and Ms. Watson knew each other overlapped with the alleged abuse. The facts about the relationship between defendant and the proposed responsible adult in Blaisdell are substantially different compared to the relationship between Mr. Stroble and Ms. Watson. In Blaisdell, the defendant was seeking approval of his romantic partner as a responsible adult. This romantic partner resided with the defendant and the victims at the same time, and she was unable to detect abuse. However, Mr. Stroble and Ms. Watson have never been in a romantic relationship, nor did they previously reside together simultaneously with the alleged victims. After having taken steps to identify an alternative responsible adult in a different county who testified that she would supervise Mr. Stroble and requesting strict conditions of release to be imposed, the defense respectfully submits that it has overcome its burden to prove that defendant should not be held in pretrial detention. The defense is not requesting this court to substitute the trial court's discretion, but rather we are asking this court to find that its order was arbitrary and clearly unreasonable and should therefore be reversed. And I will now yield the remainder of my time. Thank you.
All right, thank you, counsel. Counsel for the appellee, you may introduce yourself, your client, and proceed with your argument.
May it please the court. I'm David Gartenstein, Deputy State's Attorney. I represent the state of Vermont. It's the state's position that one of the core issues on this appeal is the primacy of the trial court's credibility findings relating to the proposed responsible adult. The trial court was in a unique position to observe and listen to that witness while she testified. Ms. Watson, although potentially well-meaning, did not disclose in her original testimony core information that the trial court ultimately focused on in making its determination that she would not be an adequate responsible adult. Ms. Watson did not report what relationship, if any, she had with Mr. Stroble. Turned out that it was revealed on cross-examination that she is the defendant's paramour's sister, and Ms. Watson represented on direct, that she knew defendant. In fact, the familiarity was attenuated at best. Cross-examination ultimately revealed that Ms. Watson had worked for the same company as the defendant, ending about 10 years ago, that they had not worked in the same place, but rather had just come into contact at the close of business when the boss was in a given location, and that for the last 10 years, she hadn't had any real interactions with defendant. Under those circumstances, the trial court made its findings of fact based upon its credibility determinations. It's not labeled in the state's appeal brief or in the trial court's findings of dishonesty. It's a matter of Ms. Watson's representations that she could act as a responsible adult because she knew the defendant, not being found credible by the trial court. Now, the standard for review on the court's exercise of discretion, whether to release defendant after the presumption in favor of hold without bail is found and exists. The trial court's rulings are reviewed based upon abuse of discretion, and the trial court's discretion is exceedingly broad.
Counsel, if I might, like to ask you the same question that I asked your brother counsel, and that is, has the court here ever committed to agreeing that someone would be an appropriate responsible adult to supervise here? In other words, in looking at everything here, it seems like the trial court said there's a risk to the community here. This is sexual abuse involving 2 children over a substantial period of time. But I don't see a discussion about whether or not having a responsible adult condition would address those concerns.
The trial court was never called on to rule out unequivocally the possibility of a responsible adult. So I think that the trial court reserved the possibility that if defendant proposed an appropriate responsible adult with sufficient conditions that would have ensured protection of public safety and protected against risk of flight, that the trial court would have considered releasing the defendant under those circumstances. And that's what exercise of the trial court's broad discretion requires. The court did not, for all purposes, rule out that possibility. The trial court made a decision in this specific case that the proposed responsible adult, Ms. Pauline Watson, would not adequately protect public safety. The court's discussion of the reasons why went back to exactly those issues that I focused on earlier, that she had made representations and those were not sufficiently supported in the record. And as a result, the court decided, based upon these facts and circumstances, that this responsible adult would not suffice.
All right, that answers my question. The idea of a responsible adult condition was not taken totally off the table.
Exactly right, Judge.
Thank you.
Mr. Gartenstein, how much weight should be given to the fact that the appellant is 52 years old with no criminal history and is gainfully employed?
Trial court has broad discretion to weigh all of the factors relating to the criminal conduct and then to exercise that discretion to determine whether to release in light of the presumption of hold without bail. I would not articulate a particular percentage or how much weight. I'm sorry not to answer the question directly. It's really a matter for the trial court to make that determination. And the trial court did recognize in its initial decision from, was it June 7th, in the original decision to hold without bail, that defendant has no criminal history and that he's been gainfully employed. I also don't know over what period of time, and that he doesn't have a history of prior criminal proceedings. The case law issued by this court has consistently held that the court weighs all of those factors together and makes its determination, and that abuse of discretion would be found if the court considers its discretion to be limited improperly in some way. And that was not Judge Treadwell's ruling to any degree. Judge Treadwell considered the extremely serious nature of the offenses. He considered defendant's history. He considered the responsible adults who were proposed in the first instance, and concluded, based upon all of those factors and his consideration of all of those factors, that the presumption had not been overcome. And that June decision was not appealed. When defendant moved in late October to propose a different responsible adult, and I'm not confident that the quote unquote material change of circumstances articulation of the standard is necessarily the correct one. Defendant had the right, as established in Tarbell, to propose another responsible adult. That's what he did. Hearing was promptly convened, and the court, based upon that proposed responsible adult's testimony, concluded that she could not serve in that role appropriately. So,
Mr. Gartenstein, is it
Judge.
your position that that the appellant here could come forward with yet another person seeking to have the court approve that person as a responsible adult?
I'm not aware of anything in the case law which would prohibit defendant from making such a proposal for a responsible person with a combination of conditions that would protect the public. And there was a question, I think, before I argued Tarbell about whether a change of circumstances needed to be shown. And this court was clear that proposal of a responsible adult, proposal with other conditions that the trial court could conclude would protect the public certainly would be appropriate. I noted in the appeal brief, and I would reiterate here, there were questions at the beginning of the appellant's argument about the role that defendant's concession that the weight of the evidence is great plays in this appeal. The concession by the defendant that the weight of the evidence is great in the initial proceedings, it determines for the purposes of this appeal and for all proceedings below that the weight of the evidence is great. With the determination as such, there is a presumption in favor of whole without bail, and that presumption exists because that's a proxy for a finding that defendant poses risk of flight and risk of harm. And the burden then shifts to the defendant to show that some condition or set of conditions, including a proposed responsible adult, would ensure adequate protection of public safety and adequate protection against risk of flight. In this case, the trial court found and concluded that defendant had not met that burden based upon its review of the evidence that was presented. It's the state's position that that finding by the trial court did not rule out any particular factors. The state did not argue that the nature of the relationship between the responsible adult and the defendant here was exactly akin to that found in Blaisdell or in Eau Claire. Rather, the state noted that it is a factor that the trial court can consider that criminal conduct was ongoing while there was a relationship between the defendant and the person proposed as a responsible adult. And the trial court considered that in this case. Spatial proximity is another factor that is properly considered, and the trial court weighed that as part of its decision of all the factors, and then exercising its exceedingly broad discretion to make the decision about whole without bail. Having properly considered those factors, it's the state's position that abuse of discretion is not shown.
All right, thank you, counsel.
Thank you.
All right, does the appellant have any time remaining?
Appellant has 4 minutes and 35 seconds remaining.
All right, counsel for the appellant, you may proceed.
Thank you. I would conclude by saying that although the weight of the evidence was conceded and the allegations are quite serious, there is no evidence to suggest that there is an ongoing risk or even a recent risk of danger to public safety. And the alleged conduct is said to have occurred a number of years ago, and there is no evidence of subsequent threats to any of the alleged victims or other juveniles.
Mr. Hashim, the late disclosure issue, and you brought that up before, wouldn't that go to the weight of the evidence and not to anything regarding a discretionary determination to hold without? I mean, isn't that been waived by Mr. Montgomery?
Yes, Your Honor, it was waived by Mr. Montgomery. And I would agree that it goes to the weight of the evidence, if I'm understanding the question correctly.
No, thank you. I think that you did understand it correctly.
Thank you. And that concludes my response. Thank you.
All right. Thank you both very much. Bailiff may call the conclusion of the case.